in.
Oh.
Good day, everyone, and welcome to today's panel discussion on changes to company directors, close corporation members, and accounting officers. I'm Elma Pinkham from the Corporate Education Unit and will be the moderator for today's program. I'm joined by my colleague Simon Vignani, who will start our program today with a few words on the Learn IBIS program. Thereafter, we're going to be joined by our panel members from different sections that work with directors changes, members, and practitioner changes. These colleagues are Mr. Thomas Lebete, who work on the company director side. Then secondly, Ms. Pietro Engelbrecht, who works with CC member changes. And then lastly, Ms. Mapule Malinda, who works with authorized practitioners. We will only respond to your questions related to today's topic, which you post under comments, so you're welcome to do so. If you have other questions that are not related, please log them on the CIPC website inquiry system. The recording will remain on the on Facebook and YouTube should you wish to watch it again at a later stage. With that, Simon, I'm going to hand over to you.
Good morning, everyone. My name is Simon Vignani from Corporate Education and Voluntary Compliance in CIPC. Yes, CIPC has introduced what we call Learn IBIS. The program is a short educational course aimed at assisting new and existing company directors to gain knowledge of their duties and responsibilities as directors and ensure compliance to governance requirements. The program is free of charge, and anyone who's interested can register on CIPC website to join the short course. One can follow the course in your own time and at your own pace. Persons that attended the course can obtain a certificate of attendance after completing the course. Please note, it's not an accredited course. And then all inquiries can be sent to e-learning@cipc.co.za. Thank you very much, Ms. Pinkham.
Thank you, Simon. I'm going to start off with Thomas Lebete and director changes. Thomas, can I just ask you before we start that you just tell us over and above director changes, is there other types of matters your unit works with as well, your subunit, can I call it that, with directors?
No, there is nothing else except.
Okay, so you focus on that. Okay. I want to remind persons who have questions, they can log them under comments and we will put them up and answer them as much as possible. Thomas, as most of us, I think, are aware, the process to amend company directors is available on the website with a step-by-step guide. But I want to ask, in the case of a Call 39 for director changes, sometimes they get rejected due to non-compliance. Can you give us an explanation of how this works?
Thank you so much, Elma. And then also I would like to thank all the audience for joining this webinar for today. Just to go straight to your question, Elma, the reason why clients sometimes get the non-compliance rejection while they try to file the application, it's due to not completing the tracking number on the subject field. Because whenever you do the filing On the subject field, the customer need to put the tracking number that appears on the e-services CR39 form and nothing else. So if they can put that tracking number, and then the application will go through. But if not, or if they write the registration number or they type in tracking number in words, then the system will not be able to read that, because it has been designed to only read the tracking numbers. So they need to put only the tracking number so that the application can go through. So that is the reason why we
Yeah.
get that protection. Yes.
Okay, thank you, Thomas. One of our customers asked, is it true that there will be penalties for rejected directors' change applications?
No, there is no penalty for rejected application. Even though clients are expected to file the application within 10 business days after the vacancy has arisen in the company, there is no penalty that will be they will be penalized on for late filing. So the 10 days period is just a standard that the company need to comply, but there is no penalty that will be paid with regard to that.
Okay. And the next question, how does one remove someone as a director if the other directors do not give consent, individual divorced, and the other party to sign documents or to sign docs is the ex will not sign documents?
Yeah, remember that there is a difference between resignation and removal. So if the director wants to remove another director, then there is a process that needs to be followed in terms of the Section 71 of Companies Act. They need to follow that process in order to remove a director, whereby that person will have to be given a notice of the meeting, as well as the resolution that has been taken, that in that meeting they are going to vote for the removal of that director, and they must also provide the reasons why that person is going to be removed, so that that person can have an opportunity to prepare a response well in advance before the date of. So clients need to differentiate between the removal and the resignation, because the resignation happens voluntarily due to personal reasons, because the director might have other commitments that he needs to pursue on, and then he will have to resign from the company. By resigning, then he will have to hand over the resignation letter and the certified ID copy to the company, so that the company can file the necessary documents to CIPC to record that change. But when it comes to the removal can happen due to incapacity of a director, due to fraud, due to theft, or any other matters that may warrant removal of the director. So there is a process that needs to be followed with regard to the removal of that director, as indicated in the Section 71 of Companies Act.
Okay, thank you, Thomas. Another question is, of late my Core 39 applications are rejected when I've provided an affidavit for the client instead of a certified or notarized ID. When did this change? I thought that the affidavit would be sufficient.
Remember, the affidavit will only be used in case the the company cannot provide the ID copy of the person who is affected by the change. For example, for the person who is resigning from the company, but they are not able to submit the ID copy of that person. So in that case, they can provide an affidavit explaining the reasons why they cannot provide the ID copy of that person. So it should not be rejected if they have provided that affidavit explaining exactly the reasons why they cannot provide the ID copy of that person. So the notarized ID is accepted. So if maybe you got rejection with regard to that, that was a wrong query. And then it is not supposed to be like that.
Before I give you this question, I just want to make a remark. CIPC does not do funding. People who want to apply for funding can contact the DTIC or Department of Trade and Competition. Our next question says, good morning. Does CIPC make provision for directors' designation in a company? For example, Chief Executive Officer, Chief Financial Officer, or Chairperson?
Yeah, currently CIPC only have designations for the directors and non-executive directors. We don't have designations for the chief executive officer, chief financial officer, or the chairperson. Those are the titles that can be used within the organization. But when we come to processing of applications, we don't have those designations in our system so that we can indicate that this one is a CFO, this one is a CEO, this one is a chairperson. They can only use those titles within the company. But when it comes to the record of the directors, we record all of them as directors or non-executive directors. Unless maybe as per the current, in fact, for the next system that will be introduced, that is where those designations are catered for. Then you can be able to indicate this one is a chairperson, this one is a chief executive officer. But under the current system, then we only cater for the designation of directors and non-executive directors.
Thomas, we also have Marumo Modiba here with me. He just wants to add on to what you've said.
Yes.
Greetings. And when they make during the formation of the board, they are not, nothing will restrict them from putting those titles internally for their own internal documentation to say this has been designated in this particular position. So as CIPC, we wouldn't restrict the company at that level. It's more of an internal matter which can be dealt with in their internal documentation. As you correctly said, however, for compliance to our documentation, we'll put the designations as you provided. Thank you.
Okay, but next is like a comment that says, I do think that you need to do an entire section on directors removal, as there are many factors that come into play, and the CIPC need to advise on these as well as when to approach the tribunal. Thomas, I think we recently did have a webinar on director changes, which you participated in. Can I just ask, if people view it, will this question be addressed?
Yes, I agree with you. But if I
You're
can
welcome
just
to give information. I don't want to stop you from giving it, but it's just that I also want to make the audience aware that there is a webinar on director changes.
Okay. Yeah, but on the issue of approaching the company's tribunal, this happens in a situation where the company has fewer than 3 directors, and then they feel that they need to remove 1 director from the company. So those matters need to be referred to company's tribunal for determination. Only if the company has fewer than 3 directors, then that matter cannot be processed at CIPC. They need to refer that to company's tribunal for determination. Which means that in a case where the company has got 2 directors, 1 director cannot remove the other director, as an example. So that matter will have to be referred to company's tribunal, unless if the person has voluntarily resigned, then that transaction can be processed at CIPC.
Okay, thank you. The next one says, if I suppose I am a sole director and want to resign and appoint a new director, what are the processes?
The process to appoint a new director and resign the existing one, they need to submit the CR39 form. And then in terms of the supporting documents, they need to co-sign the resolution, which means that both of them must sign the resolution that will state that Director A is resigning and then Director B is appointed. And then we will need their certified ID copies that are not older than 3 months. And then we must also need to get the resignation letter as well as the consent letter to be appointed as a new director. So those are the supporting documents that they need to file in order to effect that change.
Okay, next one. How can I remove myself as a company secretary wherein the directors do not respond to my email request to do so?
I think the issue of the company secretary can be handled by the Mapula's unit, where they deal with the authorized practitioners, including the company secretary. So with this one, I cannot be able to tell exactly what need to be done to remove the company secretary if maybe the directors are not responding to the calls or the emails from the company secretary.
Thank you, Thomas. In case of a mutual separation with a CEO and there is no resignation letter, how do you resign such a director from all the entities she or he was a director on?
No, remember when a person decides to resign as a director of the company, obviously he need to hand over the resignation letter to the company. So, but in a situation where the director it's a director in multiple companies, so he will have to serve those companies where he is listed as a director with the resignation letter, so that the company can be able to file necessary documents to CIPC to resign him as a director of the company. I don't know if maybe I've answered it correctly, but that's the way it should be done.
Thank you, Thomas. I do see there's a question on removal of a CoOp director. We do not have anybody in the studio today from the CoOps unit. This is only for company directors. So I want to request the customer to please log a call on the CIPC website, specifically for the CoOp unit, that division, to respond to that. And there's a question on reactivation of a CC that is still active with SARS. I think you must log a call as well, because it's not really part of what we're talking about today. Somebody's asking here, I live in France. I still want to continue my business as now I'm settled here. Fashion Force Africa. Can they do so, Thomas? Can they do changes if they sit in France to their directors?
So
because I see there's a second question where somebody's asking director has moved overseas and I'm not able to get hold of him. So there seems to be practical issues with people either being overseas and still running their companies, and others who go overseas and just disappear.
Yeah, we have a challenge with that kind of transactions whereby the director will move to oversee and then disappear and then never come back to the country. And then you find that the company is struggling to operate while he is still listed as the director. And then now they want to remove him as a director because he's not taking part in the day-to-day running of the business, and then maybe even put hold of some of the projects due to his absence. So the company can submit the resolution to CIPC to indicate that this person is nowhere to be found, and then now the company has taken the resolution to remove him as a director because now he is nowhere to be found, and then he's not doing anything for the benefit of the company. So in that case, they can file the resolution, company resolution signed by the existing directors, and then from there they will have to give us then affidavit indicating that they cannot provide the ID copy of that person because he is nowhere to be found. So those are the documents that they can submit in case they want to remove that person as a director from the company.
Thank you, Thomas. Before we continue, I just note there's a question around holding companies. I think we've been speaking about a main company and other companies. That is a structure issue and is not dealt with by CIPC. So
Yeah.
I would suggest the person contact some legal advisor who can assist them with that, or
Yes.
auditor. Then our next question, there is no resignation letter and she or he refuses to sign.
Yeah, there is no resignation letter, but the question is, has the person resigned? So if the person has resigned, then he will have to hand over the resignation letter, so that the company can be able to file the necessary documents to CIPC. Because if a person is no longer interested in a company, you cannot force that person to come and sign whatever documents that need to be signed. That is why when you file the CR39 to change the directors, we only need at least one signature of the existing director who can sign that CR39 form, and then from there they will have to prepare the resolution of the company telling CIPC that this is the change that is about to happen. But in a situation where the person is nowhere to be found, for example, and then he didn't provide the resignation letter, such should be stated in the resolution that this is the situation that the company has come across with this director, but now they want to remove him as a director of the company. Because resignation, you cannot resign me. Resignation happens voluntarily. A person need to resign to say, I have resigned. You can only remove a person, but not resign him.
Okay. If a
Yes.
director is still active internationally, so it is fine.
Internationally, in which way? If the director is still active internationally, so it is fine. So I, I don't know if maybe I will be answered it correctly, but if there is a director who is operating from overseas and then he is still listed as the director in the country, then that one we can keep that record and then there is no problem with that. The only challenge can come in a situation whereby that person is no longer taking part in the day or maybe participate in the operation of the company at all, and then or maybe is also preventing the operation of the company moving forward, then that is where we will have a challenge. But even if he's operating from outside the country, he can still be a director who is active just like any other director who is in the country.
Okay, thank you, Thomas. Before we continue, I see there's a question on a CoOp 2 form that was submitted, but they haven't received feedback. I want to ask that the customer please log a query on the CIPC website for the CoOps unit to respond. Okay, then the next question, can I use the resignation letter sent 8 months ago?
Yeah, remember the resignation letter doesn't have an expiry date. So you just need to tell CIPC when have you resigned. And then we can record that resignation using the date that you have indicated. The only thing that we cannot record is to tell CIPC that I'm going to resign in October 2023. Then that one we cannot record. But where you indicate that you have resigned in July, then we can record that one because you have already resigned and then that date has already passed. But we cannot use the future date to record resignation of a director. Because what if maybe when that time comes and then you don't want to resign anymore and then we've already registered you as a resigned director? So we cannot do using resignation using the future date.
Okay, thank you. At the moment, I can't see more questions from customers, so I'm going to ask you a few questions. Thomas,
Okay.
why does it happen that documents that get uploaded or email are not received by CIPC?
Yeah, we come across such kind of complaints from customers that they uploaded the documents or they emailed the documents, but when we check on our side, we didn't receive that application. So it normally happens because the client filed a huge document which is more than 10 megabytes. Remember, the system has been designed to accept at least 10 megabytes size of the document. So if you attach more than that, then the document will not come through. Then you can keep on phoning CIPC why I submitted my application or maybe I emailed my application, but it seems there is nothing on your side. So in most cases, it's due to the size of the document that has been submitted. It should not be more than 10 megabytes. And then if it is less than 10 megabytes, then it will go through.
Okay, thank you. How can a client inquire about the process to do changes to contact details of directors?
To change contact details of a director, we have that functionality on the website. After the client have logged on under transacting, at the bottom of screen you will see there is an icon with an A, like the one we use on the email, just like an @ on that icon you can click there, and then the system will open up, and then you can do the change of contact details there. That information is on the website.
Okay, thank you. Can I ask what will happen if a certified ID copy is not attached?
Yeah, if the certified ID copy is not attached, the application will not be processed. Remember, certified ID copies that are valid, in fact, that are within 3 months period, are acceptable to finalize the transaction. So if no ID copy has been submitted or attached, then that application will not be approved or will not be processed. So it will be rejected asking for that ID copy. So it is important to ensure that the ID copy is there because it's for the identification of the person who is being affected by the change during that time. It can be the person who is resigning, or it can be the person who has been appointed. So we will need the ID copy of those people who are affected by the change. So the certification must be within 3 months period.
Okay, thank you. The question somebody raised around a trademark, they must please log a query on the CIPC website for the trademark unit to respond. Sure, it's possible what they're asking, but then the unit can respond and tell them how to go about registering their trademark. Our next question, my Core 59 application was rejected because I did not include existing director address change form. I just updated online when applying for the Core 59. I did include the new director signed form.
I don't understand, because if you file the application to change the existing director's address, then you need to complete that information on CR39 form, indicating that this is the new change. And then at the bottom there, or maybe you have done electronic submission, then you can just indicate, maybe on a written document, it can be the resolution or whatever supporting document that you have attached, to indicate that you have changed the address. But remember, on the e-services transaction, when you go into the CIPC website and do the change of directors, you are the one who need to do the capturing of the changes that you want to make, including the address and the other information of the director. So you can capture that information. From there, you file the document to CIPC for approval. So there is no way that I can say there is a separate application or maybe separate document that need to accompany CR39 in case you want to change the address of the existing director. This can only be done on CR39 form.
Thanks, Thomas. If I can move on for now to Pietro Engelbrecht, who is with the CC member changes unit. Then we see if we can assist with that. If you've got queries on CoOp applications, please log your queries on the CIPC website. There's nobody in the studio from the CoOps unit today. Pietro, I'm going to kick off with a question from a customer who's asking what is the procedure to reactivate the CC that is still active at SARS? I don't know if you can respond on that one.
No, unfortunately, I can't respond on that. They will have to log a ticket under reinstatements.
Okay, so that's what they must do. Then I want to ask, can you explain how to change details of a CC member or members?
To change the details of the members of a CC, form CK2 must be submitted. This can be done on our website on e-services. While capturing the information on the website, customers often experience challenges when the date of birth or the date of appointment of the members are not captured, and then in that case they have to submit a ticket for us to update that information. Those are the common problems that customers experience when they do the capturing. So they can resign a member or appoint a new member or change the contact details of existing members. After capturing the information on our website, the system will generate a CK2 that must be signed by all the members of the CC. The CK2 can be uploaded on our website on e-services, or it can be emailed to e-services@cipc.co.za. It is better to upload the documents because you can attach larger attachments and the quality of the documents that we receive are better. The supporting documents that are needed will be the certified ID copies of all the members and the written instrument signed by all the members, including the new members, the consenting to the changes. It can be in the form of a sale agreement, resolution, minutes, etc. So that's the process.
Okay, thank you, Peter. A question from a customer, why can't we have an email for the manual CK2 as the other ones have emails?
I can give you the email address for manual CK2. It's manualck2@cipc.co.za. Please remember when you email documents there, it must be in PDF or TIFF format. The attachments must be no more than 10 megabytes. And you have to include your customer code when you email the documents there.
Okay. How do customers follow up on submitted documents?
To follow up on a submitted document, they can submit a query on our website. If a document, if you find that we didn't receive a document, the possible causes might be that the size of the attachment exceeded the limit, that the documents were not in the correct format, so it wasn't in PDF or TIFF format, or if it's an e-services CK2, it might be that you have not included the tracking number of the CK2 in the subject of the email.
Okay. Can you tell us, I know Thomas also referred to certified ID copies, just to make sure with CK2s as well, but there's no non-compliance. What do they do when they do certification from the IDs? I mean, what format must it be in, especially with the smart cards and so forth?
Okay, so the requirements for certification are that the ID copy must be clear and legible. And if it's a smart ID card, front and back of the smart ID card must be on one page. And if you and only one ID copy or one passport copy can be certified on a single page. The Commission of Oaths must provide the following information. You must stamp or write that the document is a true copy of the original. The Commission of Oaths must provide his designation. He must provide his full names and surname. He must sign that to confirm the certification, and then also write the date of certification. The certification may not be older than 3 months.
Okay, thank you. I just want to make a comment. Somebody asked about deregistration of a company. Please check. I'm sure we've done a webinar on that matter. You should find it on our website under webinars as a podcast. Otherwise, lock a ticket on our under inquiries on the CIPC website. Peter, can you also expand on trust documents that have to be submitted where it's applicable?
Okay, so if a trust is a member of a CC, those CK2s must be submitted manually. It cannot be done on e-services. So the supporting documents will be a copy of the letter of authority issued by the Master of the High Court. Also, the copy of the sections of the trust deed that identifies the beneficiaries of the trust. Thirdly, a signed power of attorney by each of the trustees appointing one of them as the representative of the trustees for purposes of holding and dealing with the members' interest in the CC concerned. And then a letter by the representative trustee in which he furnishes the name, registration number, and address of the trust, the names of all the trustees of the trust, the number of beneficiaries of the trust, and the particulars of all the beneficiaries. The reason why it's important for us to know who the beneficiaries are is because the beneficiaries are counted as the members of the CC. So the members of the CC, when added to the number of beneficiaries of the trust, may not exceed 10.
Okay. And what are the requirements in the case where a member is deceased?
If a member is deceased, it's the responsibility of the executor to transfer the member's interest to the correct person. So we need a CK2, and the executor must sign the CK2 on behalf of the person that has passed away. We need a copy of this letter of executorship issued by the Master of the High Court, and a copy of the certified copy of the executor's ID.
Thank you, Peter. If I may move on now also to Mapule Malinda, that she can just speak a little bit on accounting officers as well. Mapule, how do one amend an accounting officer's details?
Thank you, Alma. To amend an accounting officer, you will need a CK2A signed by all active members. All active members must also attach their certified ID copies, the consent letter of the accounting officer, and then they scan them all together to manual CK2 at cipc.co.za, and then it will go through to the back office where the changes will be done.
Okay. And how can one appoint an accounting officer?
Appointing an accounting officer, Elma, is the same as the one that I just stated now, that you have to send through a CK2A, attach the consent letter of the accounting officer, the certified ID copy of the members, all members, and then they scan and email all those documents through.
Okay. Mapule, there's a question from a customer that's asking, what is an accounting officer?
An accounting officer is a member of a recognized profession body, which is a condition of membership requires as a relative subject as an accounting officer, a person who can be the accounting officer.
Okay, can you also explain why a PTY limited or private company cannot be an accounting officer?
Because a PTY Ltd cannot be an accounting officer because it does not have it's not recognized by any professional bodies. So therefore it cannot be appointed as an accounting officer or recognized. It's a separate legal entity.
Okay. And why is a consent letter needed when appointing an accounting officer?
A consent letter is needed when appointing an accounting officer so that we as CIPC do check the points, being the practice number of the professional accounting officer, their professional body, whether where they belong, sorry, and then therefore we as CIPC do go back to the professional body and find out if they are the legitimate accounting officer. So a consent letter is needed for us to verify the details of the accounting officer.
Okay. Can I just ask that you give us some details on the consent letter?
Okay, the details of the consent letter will be the practice number of the accounting officer, the name in full of the accounting officer, the professional body of the accounting officer, the address of the accounting officer as well. Those are the four important elements on the consent letter that is needed.
Okay. And lastly, where do we send the application documents?
You send them through to manualck2@cipc.co.za. And it can only be done manually. Currently, we don't have an online accounting officer amendment.
Okay. I'm going to come back to questions from customers, and these may be mixed between director changes, CCs, and accounting officers. The first one says, based on CK2 CC amendments, whereby under directorship is the executor, show what's the procedure to remove the executor as a director, and let's say appoint the children of a deceased who was the owner of a CC. Not sure if you understand my question. Thomas, Peter, I don't know.
Thomas can be able to assist.
Okay, so if the executor is a member, if the executor is a member of the CC, the executor can transfer the member's interest to the children if that is what the will of this person says. So then the executor will submit a manual CK2. The details of the executor must be completed on page 3 of the CK2 for persons who cease to be members, and the details of the children or the new members must be completed on page 2 where the details of the active members are completed, and the certified ID copies of all the members, the executor and the customer code owner must be attached together with a written instrument confirming these changes.
Peter, if Silas or Marumu can just add on to about removal of an executor, perhaps.
Yes.
Thank you, Petro. You're right. However, I think the client hence at the end he's saying we're not sure whether he understands his question. I think it's more relating to the other aspect of the question is that can we as CIPC remove the executor? Which we
Removal on
can't because we don't appoint the executor. That process comes when through the master, so it's not something within our ambit to remove executors.
Yeah, so appointment and removal of executors of a will is with the master's office. On that, we can't respond. A next question, how do you amend the company of a member who's using a passport, and how do you amend the passport number to an ID?
How do you amend a company of a member who is using a passport? If that person changed from the passport to South African ID, what they need to do is to file the manual CR39 so that we can be able to capture that new information in the office, because you cannot be able to transact online if you are using the passport. So they need to submit the manual CR39 and then also attach the new ID copy that has been issued by the Department of Home Affairs, and then we can be able to record that in the office for them.
Okay, I saw that there's one query on MOIs. I just want to ask this customer to log a query for the MOI unit to respond to that. We can't do it here today. Thomas, you can tell me whether you're able to respond to this one. We got somebody asking a question. He's the registrar at the company's tribunal, and I often receive company hijacking applications. I want to know what the measures do you have in place to curb this from happening in the future, and what recourse do directors have when confronted with this situation?
Yeah, hey, this one it's a very serious problem, because we got a lot of complaints from customers whereby their companies have been hijacked. So in a situation like this, if they find out that there are new directors whom they don't know, or maybe they have been appointed in a company that they don't know, so the recourse here is to file the objection by filing CR 168 within 10 business days after the change has been recorded at CIPC. So, however, sometimes you find that they picked up the change of directors, which is unauthorized, after the expiry of 10 days. So what they need to do in that case, they need to file manual CR 39, and then when they complete that form, they need to indicate the unauthorized change that has made. Like on the form, they will complete the details of a director, and then at the bottom, I think it's at number 12 of the form, that is where they need to put the nature of the change. Then they will have to indicate remove unauthorized appointment, or they can indicate reinstate unauthorized resignation or removal. And then where there is no change on that particular director, then they will have to indicate no change. But if a director has been unlawfully removed or resigned from the company, and then now they want to reinstate him after the 10 days period has lapsed to file the CR 168, by filing that manual CR 39, then they need to indicate the status as such that this person has been removed and then now need to be reinstated. Then they will indicate reinstate, and then they also indicate this was unauthorized removal or unauthorized resignation. So that is the recourse that they can find from our side.
Thank you, Thomas. Marumu Modiba, just want to add on to your response.
Okay.
Thank you. I just want to share with the registrar of the tribunal that during the CIPC strategic, because the question that he raised was that in future, how are we going to ensure that we keep this problem not to continue? So hence I'm saying during the strategic session, when we were dealing with our AOP, the commissioner specifically raised a very serious concern regarding this matter, in that it affects the reputation of CIPC, and secondly, it also impacts on or become negative for the government in terms of uplifting our economy to attract foreign investment. Hence, a decision was taken, and the CIPC is having in place a governance committee that is currently directly dealing with these matters of this nature. And secondly, they have agreed to enhance system to put in additional alarming security in case of this possible hijacking. So there are very serious efforts from the strategic level of the organization to ensure that this matter is really being handled. And currently, there's been a decrease. One can see that there is some progress in this regard. Thank you.
Okay, somebody asked something about access to a CIPC certificate, which I can't get via director. I just want to ask, please log a query with a disclosure unit on our website to respond to that. Let's see this one. Good day. Why is it when the director resigned, but they still appear as incorporated company on the company documents? Thomas, can you respond to that? Marumo, can I ask you to respond to that?
It's more of saying that when a director it's appointed on your COR, they deny, and the information that will reflect upon incorporation will always differ, because remember, you can be an incorporator but not necessarily being a director, which I think Thomas would agree. Hence, that would be normally create the difference in this regard. Thank you.
Yeah, that's more likely, I think, to have to do with at the time of incorporation,
Yes.
those people were members, and I mean, the Act requires a certain number of minimum numbers, so we must always be able to show that, the application complied to the Act at the time of registration. Okay, and next question. Good day. When I am in partnership ownership company, when registering a company, do we have to provide our IDs? I think this is slightly off the topic of today, but I'm sure you have to provide your IDs, but you're welcome to log a query with a company registration unit just to give you details. You can also check our website for our step-by-step guide on registration of companies, what you are required to submit. Then Thomas, we have a question. What disqualifies a director? I think we've lost Thomas. I hope he's trying to log in again. It sometimes happens. Let me just see if he's back. Yeah, his device is giving him problems. As soon as he's back, we will continue then with the company director. Are you back, Thomas?
Yeah, the VPN was gone. Sorry about that.
Okay, we have a question which says, what disqualifies a company director?
The disqualification of a director is determined by the court. A director may be disqualified for various reasons, but it's the only court that can disqualify such a director to continue as a director of a company. So once that person has been disqualified, he will have to serve a certain sentence while in disqualification status. Then during that period, you won't be able to allow to be appointed as a director. Then sometimes you find that the person has been disqualified for a period of 5 years. It starts with 5 years and upwards. It can be 5 years, 7 years, 10 years, and then that person will be disqualified during that period. So, but that one will be determined by the court based on what issues the court find him guilty on that will warrant disqualification of him as a director. But that person, once he's under disqualification status, he cannot be appointed or act as a director of a company until such time when he is fully rehabilitated. So once he's disqualified, the court will send CIPC the court order indicating that that person has been disqualified so that we can list that person in our register. We have got a list of disqualified directors. So that person will be listed there up until such time when we get another court order that will show that the person has now been fully rehabilitated, and then now we can remove him from the list of disqualified directors so that he can now continue with his life. He can now be appointed again as a director of a company. But the disqualification, we cannot come with the exact reasons, but that one will be determined by the court why that person need to be disqualified.
Okay, the next one. How do you go about when you have, I suppose, acquired a new ID with a different surname that appears on your from what appears on your certificate, and you want to make changes, I suppose, to your details?
So if you have got a new surname as approved by Home Affairs, and then you find that currently at CIPC you have got surname A, and then now Home Affairs has approved your surname now as B, then what you will have to do, you will file because you cannot go and transact on the e-services using in order to change the new surname from the old one. So what you'll have to do is to file the manual CR39 so that that information can be captured in the office. And then after that, you can now be able to transact online because now you will be having a new surname that is in operation.
The next question is for Mapule. When is it mandatory to appoint an accounting officer?
It is mandatory for each closed corporation to appoint an accounting officer, and if a vacancy arises of a new accounting officer must be appointed within a period of 28 days. Failure to appoint an accounting officer within the designated time frame will result in non-compliance, so within 28 working days.
Thank you, Mapule. The next question, what needs to be done when you can't trace the other directors you registered with and you want to resign yourself from the company as director? What are the requirements and documents needed? Thomas, you might have already said something about it, but perhaps you can just repeat.
Yeah, this one is a very tricky because directors are appointed by the company. And then when you have to resign, then you have to resign with the company by submitting your resignation letter. And the company will have to file the necessary document to CIPC within 10 business days after you have resigned. And then if the company fails to do that within that 10 days period, it means it will be in contravention of Companies Act. And then it's then that you can lodge a complaint to CIPC by filing CR 135.1 so that the enforcement unit can force the company to comply with the resignation of that director. So it's a tricky one because you find that in most cases directors, they've got some issues, they've got some infights which need to be resolved by themselves, not by CIPC, because CIPC cannot be thrown into the infights within the companies. For example, those people who are running the company, they need to resolve whatever issues that they come across with. In case they have got some differences, and then they need to come to an agreement as to how do one resign and then how do one remain in the company. But yeah, this one it's a tricky one.
Thomas, this might be slightly similar. There is a mutual separation in a company, I suppose, between a director and the company. Both company and director agreed to separate. However, the separation was acrimonious. Then he refuses to sign a resignation letter. How do we remove him?
Yeah, I think we've already attempted deal with this one before, but where the director has resigned and then now he's not coming to cooperate to finalize the whole process, the company can submit the resolution indicating this is the situation, the director has resigned, and then unfortunately he is not cooperating with the company to submit the required documentations. But when it comes to the documents that need to be signed, the resigning director, we don't expect that person to resign to come and sign the documents, because once you handed over your resignation, it means that you are done with the company. So whatever meeting that will be held, and then it has got nothing to do with the outgoing director. So if the director has resigned, but he is not cooperating in terms of submitting the supporting documents like the ID copy or the resignation letter, so that can be explained in the company resolution. But the issue of not submitting the ID copy should be highlighted in the affidavit that this person has resigned, and then this affidavit is just to confirm that we are not able to get the ID copy from this person because he's not cooperating. Then that affidavit together with the resolution will be sufficient for us to process that change.
The next one, Marumu said he will respond to it. It says, how CIPC can assist us small SMMEs get projects, as these big companies always have their people to benefit as the SMME. I'm not sure what's that. And then he says he hopes he's not out of a topic. It is slightly out of a topic, but Marumu, if you can respond.
Thank you. I think it's a valid question. However, in that we as CIPC, in terms of the Companies Act 2008, our mandate and functions are clearly outlined in that it becomes outside the ambit of our operation. However, we, as an institution supporting SMMEs, it's also our responsibility to ensure that there is a way of highlighting or escalating such problems to the relevant institutions with similar mandate. For instance, we have an MOU with small business, and as you know that dealing with SMMEs, and as you know that DTIC itself, which we are operating under their umbrella, they have an institution which is mandated or tasked specifically to ensure that there is fairness in this process. As you know, this has more to do with procurement itself, and we are not in control of that. But from our side, I will ensure through the office of my commissioner that we escalate your matter to the relevant unit within the DTIC to support this, because I know that in one of the ministerial documents, it was really one of those matters outlined to say that there needs to be upliftment of small business to ensure that bigger companies do what is expected of them. So I will definitely ensure that this matter is escalated. Thank you.
At the moment, we don't seem to have more questions from customers. I hope I haven't skipped anybody. But I want to ask the question. I don't know if you've already responded to something similar, Thomas, but what happens in the case of a death of a sole director?
Yeah, thank you for that one. Um, Let me put it like this, practically speaking, that the company only operates through its directors. And that once a sole director dies, a company will be unable to conduct business. And this will have a negative effect on the business continuity. So if the sole director is also the sole shareholder, there will be no person who will appoint new directors, since directors are generally appointed by the shareholders. So in a situation like this, we normally have the executors who may be appointed to come and manage the estate of the deceased, including the appointment of the new directors um, as part of his duties as an executor. So the executor will have to be appointed. In other cases, you find that before the deceased director dies, he has got maybe a will, for example, whereby he indicated that so and so will be the executor. So if the will is there, the Master of High Court will have to issue executorship letters to those people who has been appointed by the deceased while he was still alive to come and manage the estate of the deceased. So in a situation whereby there is no executor that has been appointed by the deceased while he was still alive, then the Master of High Court will have to appoint an executor who will come and take over the activities of the company for time being, and then also appoint the person who may be the director of the company moving forward.
Thank you, Thomas. As there are no more questions, I'm just going to give each of our panel members a chance. In case there's any information they still wanted to share before we close the webinar. I see there's another question on deregistration. There is a unit working with deregistration in CIPC, so I'm going to ask that you send a query or inquiry on our website, as we don't have anybody from that unit in the webinar at the moment. But Thomas, is there anything else you want to share with the audience?
Yes, maybe to add on the issue of the sole director, who is also the sole shareholder who passed on. So when now they have to appoint the new director, we need to get confirmation that the deceased was also the shareholder, which means that we will need the share register certificate to prove that that deceased director was also a shareholder. Because sometimes it happens that the person dies, and then the remaining family members, for example, they claim that he was the shareholder, whereas we have got shareholders outside there who are supposed to come and take over the process of appointing new directors. So when they have to appoint a new director, we will need the share register certificate to prove that the deceased was indeed the sole shareholder, because we don't have a record of shareholders at CIPC. So the company need to provide us with the share register certificate that will show that the deceased was indeed the sole director and the sole shareholder. Is then that now the executor can now proceed and appoint the new directors of the company.
Thank you, Thomas. Pietro, do you have anything you want to share with our audience before we close?
Thank you, Elma. No, there's nothing from my side.
And then, Mapule, is there something from you?
No, Elma, nothing from my side as well.
Okay, I see there's one or two questions. Maruma asked he would like to respond to this one. Oh, it's off a topic, but it says, how can I deregister a company? The company uh, is or ceased trading in 2017. There were 4 members, and I cannot get hold of a one member, and another one has passed on in 2021.
Thank you. I think this question matches, it may be out of scope, but it's linked to the response that my colleague Thomas responded to in terms of saying, I recall when a similar question was asked to say, if you can't get hold of a member, it's a similar situation, same response that he gave, that there will be a resolution still applies to the question that has been raised here, where it will be clearly indicated to CIPC to say this is what transpired in the resolution of the company. And your question specifically on the registration, the facts you provided to us is that the company ceased to operate in 2017. That on its own, in terms of the act itself, Thomas would agree with me that the 2017, if some company ceased operating, the annual returns kicks in, and automatically, due to non-compliance in terms of annual returns not being submitted, the status could be different in terms of not being alive anymore. Hence, I'm saying you can proceed, nothing stops you from, but please, my advice to you, go to our website, check the status of your company, because you could be talking about a company that is already dead. Thank you.
No, you're right.
I see a few questions has come up again. This one says, my friend is asking if he can put his son as director, but he will not be active as he's still a minor. What are the processes needed to be followed?
No, a minor cannot be appointed as a director.
Okay, short and sweet. I just want to say to this person who asked about the amendment of directors of co-ops, please check our website. There is details on amendments to co-op directors. It's a co-op 2 form, but there are additional information you must provide. But it's all available on our website. If you still struggle, log a call for the co-ops unit. Then this question, how does one handle a case whereby as we are 4 directors and the other 3 directors are inactive and do not show interest in the company?
Yeah, you see, as I've indicated before, these are the internal infights within the directors themselves that need to be resolved within the company. CIPC cannot come and intermediate whatever differences are taking place within the company. So if there are 4 directors, as the client has indicated, and the other 3 directors are inactive and they do not show interest in the company, then they will need to resign because they are no longer interested in the company. Then they are expected to resign so that the remaining director can continue with the business. Simple as that.
Yeah, if Maruma can just add on to that, Thomas.
I supported the response, and I think my colleague Thomas, we need perhaps to try and more educate people to say that they need to make use of the company's tribunal, because the entity itself's mandate is very clear to say it's an alternative dispute resolution. That is a platform that they need to start encouraging our people to kindly go or view the website of the company's tribunal. And we are blessed to be having the register of tribunal on your event today. And I think more people should try and use it. And once our people are clearly educated to say such a platform exists, when they have this internal problems we've highlighted, especially the directors, to cooperate and do whatever is required, they will be guided properly by them. Thank you.
Maruma, perhaps we can look into having a combined webinar with the tribunal that these kind of matters can be discussed to make customers aware. Okay, lastly, I've got a question here. If a company wants to appoint a new director, what documents are needed?
They need to submit COR 39 form accompanied by the resolution confirming the appointment of a new director. They must also submit the certified ID copy of the newly appointed director, and then that newly appointed director must also submit his consent letter confirming that he is appointed, or he confirms, or he accepts to be appointed as a director of the company. So these are the documents that need to accompany COR 39 form.
Okay, thank you very much, Thomas. I think this brings us to the end of our panel discussion today. So I don't see any further questions from customers. I want to thank our audience for joining us and asking questions. I hope the webinar has been of value to you, and we hope to see you at the next webinar. Have a good day. Bye-bye.
Thank you so much.
Thank you. Goodbye.
Thank you. Thank you, everyone. Bye-bye.
Well